database folks in here. I'm excited to have you. Okay, my name is Ansley Sharp. I serve as Senior Assistant Registrar for Registration and Customer Relations, and I am very well aware that I am all that stands between you and the end of your workday today. So I promise to do my absolute best to stay on point and hold off the sidebars and the fun stories that I have found in researching this presentation, and I will get you out of here as soon as possible. And we'll hopefully leave time so that you can ask any questions that you may have. I already have one person in the audience who I know has self-admitted don't know much about FERPA. So there are various levels of knowledge in this room, of course. So we'll go ahead and get started. A little bit more about the Family Education Rights and Privacy Act and the mouthful, the European Union's General Data Protection Regulation, okay? The Registrar's Office really prides itself on being the record keeper for Georgia Tech students and alumni, and FERPA and the EU's GDPR are two of the policies that dictate what rights a student has and how Georgia Tech is required to protect those rights. I know that I really enjoyed all of our previous sessions today, and hopefully we'll enjoy them just as much in the days to come, but we talk all about data. More importantly for this presentation, what is the data? Who is the data? And that, of course, is our students. So I feel it's really important to know what rights they have when it comes to their record, who can see it, and how it can be used. Most of you are familiar, at least a little bit, with FERPA and that it protects student records. So what I'm going to focus on today is actually more of the political impetus for FERPA and the changes that it's undergone since 1974 when it was first enacted into law. My background is in history, full disclosure, so I really enjoyed doing this part of the research for the presentation and diving into Supreme Court documents. It's really fun to me to see how FERPA is a product of the times and how it's continued to evolve and how it continues to have to change as our technology changes. I'll move into how Georgia Tech interprets and applies FERPA, which can be a little bit different than some of our USG peers. And then lastly, I'll cover the EU GDPR, which is newer and only adopted since 2014. So here's our actual definition of FERPA, and this is actually the original 1974 language. That part really hasn't changed, but we are going to get to what has changed over the next few slides and what continues to change. So in case you weren't aware, this law protects the privacy of student records. We comply because it's the right thing to do. We always want people's data to be secure, but also because we receive funding and we want to continue to receive funding from the federal government in the form of grants and Title IV student aid, which is obviously a big deal to those who attend here. So that part, this definition is probably what you're familiar with, but where did this actually come from and why? So a little bit about the history. So prior to FERPA, it was kind of like the Wild West with student records. People wrote all kinds of things, anything from the color of somebody's hair, their stature, to things a little more salacious like their parents' political party, okay? In the 1970s and before, there's certainly a lot going on. We have the Red Scare in the 50s, Cold War is still going on, late 60s. And then you also have the rise of political movements like the Black Panthers, okay? So there's a lot going on. There's really no standard prior to 74 to allow students and parents to review anything that a school has. A school can keep whatever it wants, and it can decide who gets to see it, which very often was not the student or the parent. So kind of a major turning point came in Doe versus McMillan, which was filed in 1971. It all started with a struggling school system actually in the District of Columbia. Okay, in 1969, the House of Representatives authorized a very creatively named committee on the District of Columbia to investigate this school system and to make recommendations on improvements. Nothing wrong with that, right? That is pretty standard. That's really what you want your government to do, is to try to make things better. However, when we get to the actual report, that's where things get a little crazy. The committee submitted their report in 1970. It was about 450 pages, which is pretty much nothing for Congress. That's a drop in the bucket. And it has all the normal things that you would expect. Absence lists, test scores, reading results, in order to give a really realistic view of, quote unquote, a troubled school and the apparent lack of administration it suffered from. However, also included in this disciplinary report was more salacious stuff like alleged sexual advances students made toward each other and their teachers. If a student had bedwetting problems or had problems at school, that was reported. So really more salacious things. The important thing to note here, none of this was redacted. So these are real people, they're real information, just out there for the people on this committee to see. So once that information is compiled, it becomes a public record. So if you try hard enough, you can find anything. And again, it's trained to, in historical research, you really can find pretty much anything if you try hard enough and are willing to sift through documents. So you can imagine just the horror when students find out this information is actually a public record. It could really affect a student's reputation. And so obviously it was very concerning. So as a result of this list being compiled, a year later, students from Jefferson Middle School, we have these students to thank for the start of FERPA really, and their parents, they brought suit against all kinds of people, including the House committee that compiled the report, their employees, so their aides, secretaries, the staff in the center who copied the records, literally they are listed in here. They would have seen the list, DC school officials, and last but not least, just thrown in the United States there just for kicks, might as well when you're filing suit. So it took 2 years for this case to work its way up through the court system. And finally, in 1973, it was heard by the Supreme Court. The Supreme Court upheld all of the rulings, I'm sad to say. The defendants did nothing illegal. Their actions were protected by law. Okay, so this was obviously, I would imagine if I'm in middle school, that's pretty shocking that anybody in my class could really go and look at this information if they wanted to. So we head on later into the 70s, and if you think about where we were as a nation, trust in the government is pretty low. In fact, if you're kind of a movie buff like I am, Doe versus McMillan specifically references the Pentagon Papers. So if you know anything about that document, lots of salacious allegations in there. So clearly some guidance was needed. There really wasn't any. Schools could do what they want and keep what they want. So really an article that really brought a lot of attention, it's in Parade magazine. I don't know if anybody remembers Parade. I haven't received a newspaper in many, many years, but it used to come on Sunday and it was in the little circular in the middle. But I always remember reading it with my dad. So it really got a lot of bandwidth back in the 70s though. But Diana DeVokie, who was actually a journalist, but always wrote about issues on education, specifically education pedagogy, she wrote a compelling article about how secret records can hurt your child in 1974. And she discusses the trend of working with the whole child. So not just academic results, but personality traits, behavioral issues. So as a result of this trend, more anecdotal information is in the student files. But while I certainly think there is good and bad to this, for the scope of our discussion today, we're going to stick on just the records themselves. So I do certainly think there is an argument to be made there for some of that information being helpful. However, outside the scope here, because we have a limited amount of time. So within a month of this article being published, so it was clearly in the works, nothing in Congress moves that fast, as we all know. That is when we have a working Congress. But Senator James Buckley from New York proposed FERPA. It's also called the Buckley Amendment. I like to think it was a group effort, so I won't refer to it as the Buckley Amendment again. But James Buckley was the one who proposed it. It was a one-term senator, so a pretty fair piece of, not just a pretty major piece of legislation to be pushed through for a one-term guy, right? FERPA was signed into law in 1974. Nixon supported it, but as you know, by 1974, he was obviously out the door. And Nixon was a big supporter of rules like this that allow people to have more control over their information, which is all very ironic. As we know, the reason he left was surrounding records. But Nixon was also an early supporter of the Fair Credit Reporting Act, which, as you know, it allows us access to all that information. So again, ironic that that's what eventually brought him down with the Watergate scandal. So Nixon resigns in August. FERPA goes into effect in November. So we actually have President Gerald Ford to thank for FERPA because he signed it into law the second week on the job. Now, was it popular? Absolutely not. Probably at the secondary ed level, more popularity. Academic institutions did not like it at first. Everybody thought it was good in theory, but it needed some more fine tuning before it was passed. So it really took everybody a few years to get on board. A good example that I found amusing was letters of recommendation under this new law in 74 are now available for college students to request and review. So schools know this is coming. What does Harvard do? They immediately go into their admission office and start pulling and destroying all their letters of recommendation. I'm not sure what they were afraid was in there, but they started destroying everything. Yale refused to let students go back before November 1974 to review anything. They're like, nope, December on, you can make a FERPA request. I reviewed the Georgia Tech catalogs. These actually don't include any reference of FERPA until the early 1980s. So there was a little bit of pushback. People were slow to adopt it, even though it was federal law. The Department of Education still has to enforce it, right? And that can often be very, very difficult. So as you can only imagine, from 1974, things have certainly changed. There's been 10 amendments. I chose, just to keep things moving a little bit, on the amendments that deal mainly with security. So for instance, in 1990, we have the Campus Security Act, which is eventually in 1998 going to be renamed the Clery Act, which you are all probably very familiar with. But this came about, unfortunately, after a brutal murder on the Lehigh University campus in 1986. But this allowed schools to disclose disciplinary proceedings from a perpetrator to the victim. You all probably get the emails. You have to notify the campus community if there's a crime on or around campus. And then, of course, the annual Clery report, you can see all of the crime statistics for campus. None of that was there prior to 1990. Okay, make sure I'm okay on time. In 1998, schools can now disclose to parent or legal guardians alcohol violations if a student is under 21. Less amusing, of course, is the 2001 passage of the Patriot Act, and we all certainly know what that is about. But this allowed the U.S. Attorney General to require by law schools to provide information for anyone who had suspected ties to international terror, domestic terrorism. So we all certainly know what that is about. And then 2009, additional amendments were added to give schools greater discretion in disclosing information across the campus community when there is a threat to student health or to student safety. And that can be in the instance of one student themselves, or the campus community. And this was as a result of the Virginia Tech incident in 2007. And in doing my research, I tried not to get too far down that rabbit hole. Imagine it was not a happy bit of research. But apparently the signs were there. Multiple different offices on campus knew about trouble, but nobody was talking to anybody else. So now in 2009, this amendment allows schools and their departments to really talk more to each other without fear of FERPA, which, it's definitely still a discussion, but that is covered now in cases of security. So I've talked to you about the law now. Let's talk about what the actual education records are. Again, this is still our original 1974 language. So an education record, anything that is related to the student that the school maintains, or anything that an educational agency contracts out. So the best example I always have is the registrar's office, National Student Clearinghouse. And if you've helped us make sure, I know Mark Gravitt, my colleague, has helped us make sure we get the files to them, but they have to have the access to do what we need them to do. So as long as they're a third party we contract with, that is now part of the student's education record, even though it lies with a different institution organization. I didn't put it on here, but this also includes housing records. We often in the registrar's office get a lot of questions about that as well. I am always interested to see what will become an institution or education record next. I think this is the area where you're likely to see a lot of changes. And I think about when we implemented Canvas, all those types of records. If there is a chat on Canvas, is that technically included? I think you can make an argument for yes and no, depending on what is being discussed. But I expect this is what will continue to change. What is your education record? I think you can make it for a lot of different things. So who is covered under FERPA? It applies to those who attend, but be aware each school gets to define what an attendance means. So again, our USG partner schools may define it differently than Georgia Tech does. Georgia Tech limits it to those who are enrolled in courses, not just admitted. Okay, so if you're not actually here and enrolled in courses, you really don't have any rights under FERPA. So this is certainly a fine line as we go through the facet season over the summer. So if you're a Georgia Tech employee or perhaps you have a child here, you know what that means. You come to orientation, you register FERPA, you now have rights under FERPA. you decide in August to drop those classes and not register at Georgia Tech anymore, you no longer have access. And that is a policy that Georgia Tech has defined for ourselves, and every school has the decision on how they want to do that. Once a student is covered, they're always covered, okay, till death do us part, basically. Even if you have one term where you enrolled with one withdrawal, you have access under FERPA. That counts as attendance, okay? So we know what FERPA is, we know what and who it covers, but what does it actually mean for a student? Why do they care other than that it protects their records, okay? So students have 4 key rights as designated by the Department of Education and Congress under the original law. So a student has the right to inspect and review their record, request an amendment if they find something that is incorrect. They have the right to consent to disclosure, and it's America. They have a right to file a complaint, of course. Everybody wants to know, who can I speak to? Who can I take it up the chain to? And in this case, this is the Department of Education. They are the official final say on anything having to do with a FERPA issue. So how does this actually play out at Georgia Tech? How do we handle this? The student would request to review their record with my team in the registrar's office, and we really try to whittle down what they're trying to get at. A lot of times students will come to us and say, I want to see all my records. What does that actually mean? Does it mean your admission file? Does it mean any email where I mentioned your name? Does it mean housing? What does it actually mean? So we try to whittle that down, and I'm here to tell you as the person who does this most often, 9 times out of 10, they want to see their admission file. That seems to be the thing that people want to see. They want to see what we said about them in the review process, and a lot of times there's not a lot there. Tech has a very streamlined admission process. It's quick. We know what we're for. So usually they leave my office a little disappointed because it's less than what they were expecting to see. So I want to take a quick pause here and focus for a second on consent to disclose. This is one that all schools have the ability to define for themselves if they're going to allow a comprehensive waiver or not. So in layman's terms, we allow students to give access to anybody. The answer is no. Okay, Georgia Tech, I would say, is different from our peer schools in that we do not allow any type of release form for a student to say, I would like my mother to have access to anything, any part of my record whenever she wants. That's not how we have chosen to do things. And that, I will say, is a very difficult thing sometimes. Parents go from having a student in secondary education environment where they can see everything all the time. But once that student hits 18 or enrolls, because we have many students at Tech who enroll before they're 18, that right immediately transfers to the student. That is definitely very difficult for parents to work with sometimes. It comes up every year during a facet orientation with, hey, I whipped up this document that I'd like to give you so that you can talk to my dad about everything. Fortunately, we do not have that type of policy. The student is the only one who has free range to access their record whenever they want, okay? Student is going to be responsible for transferring any information that they see fit to have access. There are, of course, exceptions that come with things like personal emergencies, but it really comes down to the student. And I would say we have students who love this and we have students who hate this. So some students don't want to have to think about it, give my parents rights, and some are like, thank you for not talking to my parent. I didn't want them to know this, or I'm really proud when they say, I would really like to learn how to handle this on my own. I want to be responsible for this. There's always that one student a year, and my colleagues can attest to this, that comes in and they haven't actually earned that degree and their parents want to know where their diploma is. Speak to them. That is a conversation you're going to have with your parent. And we do not get involved. That is a family discussion that you will need to have. Okay, so we've talked about what rights students have. So what right does Georgia Tech have? We've been talking about this data we collect all day, and that is our student data. So there's different types of FERPA data that I want everyone to be aware of. I would refer to it lovingly as directory information and everything else. Okay, so directory information is what is available without release from the student. And this is it's a much smaller list of things that we do not need a student to consent to release before we give it out. Okay, so let's look at our directory information. I have on the left our original list from 1974 and our 2023 list. Not super different, all things considered. So this information is what Georgia Tech, its employees, its contractors can release without getting explicit permission from the student. That means that we can share it. Now, that doesn't mean that we will, okay? But it just means that every time I need to confirm if a student actually graduated, I don't have to go to the student and get a written consent form from them, okay? It allows us to do business, honestly. If we had to confirm all 3,000 degrees that we award every term, there's no way we would do anything else other than that. So directory information is posted annually in our catalog so that students know what we can release without their permission, okay? The option around that is for students to file a confidentiality flag with the registrar's team, and that basically makes them a ghost in all Georgia Tech systems. People who have access to the kind of the back end of student records will still be able to see it, but it won't show up in some of our other systems like the National Student Clearinghouse. So when looking at this list, notice we're not including things like date of birth and place of birth, which was there in 1974. We all know why. It's become a little too easy to steal someone's identity, I feel. Georgia Tech's Registrar's Office and GT Legal review this annually to make sure everything's still applicable. The last update was in 2020, and we actually removed something in that year. We removed permanent address, which people do request pretty often, I would say, during an open records request. And so GT Legal approved the removal of that item. So now people can only get access to a campus mailing address, which not everybody has one. Not everybody has a campus PO box. So that is one way. I'm really proud that we took that step. I don't know, it feels weird for someone to be able to get my permanent address just because I go to school here. So I think that was definitely, I think that's definitely a good move, actually. And I'm glad we continue to review this every year. I'm always weirded out that weight and height was included in 1974 because it just seems so opposite from where we are now as a nation. But then you think about it, if you watch ESPN every Saturday, you can get a lot of that same information. So at least it's limited to athletic team members. You're probably going to be able to get that somewhere else anyway. So I've told you what information that we can release without consent from a student, but what if you need more? What if you actually do need their transfer credit? You do need their GPA. How are you able to work around this, this limitation? And the answer is as easy as it sounds, legitimate educational interest, which is what I would say everybody who's listening in online, everybody who's in this room, you're an employee of the institution. If you need this information to do your job, it's absolutely okay to share. The list that I have is certainly not all encompassing, but if, for instance, an academic advisor emails the registrar's office and says, I really need a list of all of our student GPAs, amalgamated, that type of thing. If they can give a legitimate reason why they need it to do their job, that's okay. It's okay, even though that's not directory information, okay? So this is really where we are with FERPA as a policy, as law, as a legislation, okay? A major curveball comes along in 1990 when we start our new campus at Georgia Tech. It was then called Lorraine, but it's in Metz, France. It's been rebranded very lovingly to GT Europe. A couple of members of their staff are on campus this week, and just a lovely group of colleagues to work with. So with this new campus in a different country, this added some different layers of security that is needed. Specifically, the European Union's General Data Protection Law, and it's a privacy notice that we have to share with all of our students. Okay, now I want you to know this is not just FERPA for Europe. Okay, this is more than that. You can think of it that way if you want, but this is actually for anyone who is located within the boundaries of the EU, even if they're a U.S. citizen. If they're a GT Atlanta student studying in GTE, they're covered under this policy. Don't have to be an EU citizen. This is anybody from, you're on the train and you're applying to GT and you submit your application while flying through the EU or on a train in Belgium, it applies to you. So it applies to a lot of different people. Doesn't matter where the data is stored. As you guys know better than I do, all the data is stored here because it's all digital, still applies because we have people actually in the EU. So here's what it actually does. Now, just to be clear, it does way more than this, but these are the items that I felt really hit home with what we're reviewing today. So I won't read each and every one of these, of course, but I did want to point out that my favorite is the right to be forgotten, which is what it's actually known as, the rule of the right to be forgotten. And that just means a student can request a full delete of their record should they want to. Not saying that happens often, but they could if they really wanted to, okay? To kind of make sure we're covered on this, Georgia Tech in 2018 added a new line item to our application for admission and readmission with just that basic question. Are you now or will you be in the EU during any point of your application or your study at Georgia Tech? Just so if we needed to pull that information, we can tell you what students disclose that information, okay? So what happens if you don't comply? You could ask Amazon, who was fined $888 million 2 years ago for their privacy practices. Apparently their little pop-up window with their, these are our practices, was not sufficient, and they were fined. You can either be fined, there's a base level or the maximum amount of your earnings, which is obviously why Amazon's going to be the biggest. But this goes through the European Union directly. Department of Education cannot save us if this happens. And I would say, at least based on my reading, the EU is very aggressive in enforcing these rules, and not for a bad reason. I think it's definitely a good reason. I just think in Georgia Tech's situation, it's difficult because we have all of these different things that we have to look at. So this is what applies in Georgia Tech Europe. They have all of the things that they are required to be aware of. And they do pretty intensive training on GDPR, but they also have to be aware of FERPA. They also have to be aware of French law. They also have to be aware of all the cybersecurity policies. There was a great presentation on that earlier as well, just general good policy. They also have to be aware of the academic policy. So there is definitely a lot to consider when doing business in GT Europe. And it's definitely changed the way, and again, I think it's a good thing, definitely, the way that we store things and the types of questions that we ask. If you've had the fun, I think, to look at some of our old GT applications, we used to ask everything. What's your religion? All the kind of thing that is simply not allowed under this law. So love it or hate it, it's here and it's not going anywhere. And so GT and the registrar's office and GT Legal mainly pivoted very quickly when this was enacted in 2018 because we had to. And you know, the GT Europe campus is such a vital part of our community, and we want to make sure we're following all the rules there as well. So I promised to speed through this so we have time for questions and time to get everybody out of here. So I'd like to turn it over to you now. Are there any questions or any clarifying pieces of information that I can share? Yes.
On that last slide, you mentioned something about the one before, sorry, about asking the school or company to stop processing their data. What does that mean for Georgia Tech?
That means you probably have an application in progress and you're saying, I don't ever want to complete this application, you need to wipe that I was ever here. And that's, and other people could speak to this better than I could, but we created a GTID for you. You'll always live in the system. I do that paperwork all the time with, I need you to tell this school that I never attended. Well, why are you in the system? You applied at some point or another. But they could legally under this ask us to wipe that record completely. So I don't love that from a record keeping perspective, but we don't want to be fined either. So I think that's good. And I think this is just me pontificating here, but if a student was denied at some point and they didn't want that record on there anywhere, they could be asked for that to be wiped and there wouldn't be that record anymore. It's not a bad idea now that I think about it, but it's, so no, I don't say that people invoke this often. I know there has been one case since I've been reviewing this policy over the past few years where a student did ask for a history, a log, if you will, for every person that had viewed his data. And I know my boss's boss, Rita Bukowski, the registrar, had to work with probably many different offices to come up with that data of who has touched it. I can't even imagine. I know it took quite a bit of time. So I wouldn't say this is something that hopefully stresses people out, but I think it is important to know what it is because our population is growing, especially internationally, all the time.
So we do have one online for inclusion regarding asking no more use for it. We only hold course data for life because we never know when we need a transfer.
So that's a really good question. So we are required to hold academic information for the life of a student per our USG records retention policies, but we don't have to hold everything. So technically, for instance, we have to hold the final admission report and then we can destroy everything else after 5 years. So if a student wanted to wipe their record, it has not happened to my knowledge, Doreen, but they could, but then that does them harm. I would only imagine if that academic record is no longer here. So I would say that's a catch-22. Yes, you could file an appeal with GT Legal, who would handle this, to wipe the record, but then there wouldn't be any way for us to get it back, which is kind of scary. I'm sure I don't know that there's a way to get it back after that. I'm sure we'd have to provide proof that it was gone. But hopefully that answers your question. Please let me know if it does not. I've never had that request though, thank goodness. So that's pretty drastic. That's definitely pretty drastic.
Are there Georgia Tech or BOR data retention policies that would ride GDPR, or is GDPR like, can we say, no, we will not be able to honor your GDPR request because of X, Y, and Z?
We would be in danger of being fined. And I'm not the math person. I wouldn't want to speculate what that fine would be. And I do think most students, if you explain it to them, like once this is gone, like that's it. Your degree is never here. I think we would instead explain the confidentiality flag. If it was a security issue, which we have had where a student really did not need anybody to know where they were, confidentiality flag, not completely gone, but hidden, kind of a ghost. Mark?
I will note that the confidentiality flag does, as you seasonally appropriately refer to them as a ghost, reduce them to that. It does, while a student is here, have some implications in that certain things will stop working for them.
Mark's had to deal with that. We had a student who really wanted to come and, not to our office, but to rent a laptop or a room space. You don't exist as a student. You're a confidential student. You can't do that. It took us a while to figure out why, but they couldn't. The other biggie that Mark and I deal with a fair amount is students who they put the confidentiality flag on and now they want to graduate. If you're confidential, we're not going to print your name in the program. You're not going to show up on our commencement list. So it's a catch-22. I think it's a great thing, but you do just need to be aware of it. And also remember that you did it after 4 years. You're like, why wasn't my name on the program? Who are you? No, you're a confidential student. You're a confidential student. So it's important to remind students. And I will say in my experience, we don't have a lot of students taking advantage of the confidentiality flag. And I handle our open records request, which I did not go into because that is the Georgia state law. But an open records request, because I just have a few 5 minutes. I'm good. Okay. Okay, good. But an open records request, and I thought it was a little bit outside the scope of this because it's a Georgia state law, but anybody could file an open records request based on Georgia statute. I can't remember, but anybody could request directory information that way. And while we wouldn't be able to say, I want this specific student's record, if they're not confidential, they'll pop up on a directory information, an open records request, and then that information will be there. So I do a lot of open records requests, and it's normally things like, hey, we want to market our apartment complex to students. Can we get a list of all student names and email addresses? I don't really need any more spam. If you've seen a student email account, I watched my student worker last week, and it was just like, he just kept getting emails while we were sitting there working on something. So they get a lot of email. So I wish more people knew about the confidentiality flag, but we don't have a lot of people take advantage of it, unfortunately, I think. Mark?
I'll note that the students who have come specifically to me for confidentiality flags have been dealing with stalkers.
Yeah, and that's a legitimate reason. I'm so glad we have it for people who are fearful that someone is going to be able to locate them, so on and so forth. That's I think why the policy was put into place, you know, so people, if they really don't want someone knowing where they are, I think that's very important. Absolutely.
We do have another one online from Judy Willis. What if a student has sponsor requirement to complete training as a GRA, then they want to be forgotten? You need to show that the employee satisfied the requirement.
That's a tough one. Absolutely, Judy. That's a tough one. That's one that we would definitely pull GT Legal in on to make sure that we are following everything. And I'm assuming based on the question that this is either an EU citizen or it's somebody, someone who's actually physically in the EU. If they're working at GTE, and that would be a concern. But I also think it's important to note that I would argue there is a difference between your education record and then also a separate HR record. Like there is a separate medical record. And that I would argue, I am not an attorney, but I would argue that would be that type of information would be protected under a different set of laws. Yeah, we could delete it from your education record. However, our HR records are governed by something completely different. Still could be dicey because the EU policy does cover all types of records. My husband actually walked by when I was doing more research on this, and he does not work in education. He's like, oh gosh, what happened? Why are you having to deal with that? He works for Delta, full disclosure, and he does work in the EU sometimes. He's like, oh gosh, you know, he just rolled his eyes. So it is something that we have to deal with. So that would be my answer there, Judy, is you could probably ask that we delete your education record. However, under an employment record, I would argue that some of that stuff is still valid. I would argue. So not a perfect answer, but that is my initial thought on that question. Anybody else? Okay. Well, thank you all so much for coming today. It's been fun to have this discussion with you. Thanks to my colleague, Mark Graffin, who should have been up here with me leading this presentation, because Mark has done a lot of this himself. Please don't hesitate to reach out to me if you think of anything else that's like a weird question that you don't want to answer right now. I'm always happy to discuss FERPA more. I think it's fun to a certain extent, so please don't hesitate. Otherwise, have a great afternoon, and we'll see you tomorrow for more good sessions.